welcome. It's great to see you all here. And so, welcome to the Downtown Charter Series. For those of you who don't know, this is a series that the Faculty of Law Center for Constitutional Studies holds about every month. We do about 6 of these a year, 6 to 7 a year, and the purpose is to explain the Charter to members of the public. And we try to make these accessible to members of the public, which is why we hold them downtown. So I'd like to begin by acknowledging that we are on Treaty 6 territory, which is the traditional lands of many Indigenous people who settled and governed this land, the Cree, the Saulteaux, the Métis, the Blackfoot, and the Nakota Sioux. And of course, as a result of the treaty, this is now shared land since 1876. My name is Pat Parody. I'm the Executive Director of the Center for Constitutional Studies. I'd like to thank Wayne McDonald and Carrie Sawatsky, who organized these events here at Enterprise Square for us, and also Martin Godhelf, who's at the back there recording the event. He's our administrator, and he does all the logistical organization. So thank you, and thank you to all of you for making it out on your lunch hour. Now, just a few housekeeping notes. Please ensure that your cell phones are turned off or on silent. The bathrooms, in case any of you have to use the washroom, are down the hall, and there's a code there just beside the door, and you have to memorize the code before you go to the washroom, just to let you know. All right, and if you can get in. And we appreciate audience feedback, so please, if you wouldn't mind filling out those feedback forms on your tables when you're leaving, we really do read them. And so if you have any suggestions for us, we're very happy to hear them. And for those of you who want to be notified about our events and are not getting these by email, please do sign up. We have a sign-up sheet at the entrance of the room. Note too that we are taping today's session, so if you don't want to be taped, what we suggest is that you sit near the back of the room. That way you won't be in the line of fire, as it were. All right, so now.
Sorry, I'm turning off my cell phone.
Okay. I'm going to have the great pleasure of introducing our guest speaker, who's going to be speaking on what you know to be an extremely topical subject, the duty to consult, and particularly topical given the Advanced Mountain decision that came down this week. So Catherine is a professor of law at the University of Alberta, where she has taught for more than 30 years, not 50, sorry, not trying to for more than 30 years. She specializes in Indigenous rights, cultural heritage law, collaborative research, and Indigenous research ethics. And notably, she has developed the Faculty of Law's Low-Income Clinical Law Program and the Indigenous Justice Externship Program on Gladue sentencing principles. So she teaches students how to actually write Gladue reports for Indigenous accused. Both of those are very well attended. Professor Bell has been a visitor at national and international universities and has developed Indigenous legal education programs across Canada, most recently as part of the Nunavut Law Program. She is widely published in the area of Indigenous rights and has worked in collaboration with Métis, First Nations, Inuit, federal and provincial, and intergovernmental bodies and organizations. In 2012, Professor Bell was awarded the Raymond Natition Governor General Gold Medal, recognizing her outstanding contributions to Aboriginal law and legal education in Canada. And it is interesting that until very recently, Professor Bell was the only professor in the Faculty of Law teaching Aboriginal law. She did that for many, many years. She's always been a very busy and dedicated person, and we're very, very pleased to have her here today.
Thank you. Can you all hear me? Okay, I'm going to put on my professor voice because apparently this mic is clicking in and out, so I want to make sure that everyone can hear me. Thank you, Pat, for that lovely introduction. It kind of made me feel a bit exhausted. I'm now semi-retired, and you know why. I just want to talk a little bit about the duty to consult today. The duty to consult, and where appropriate, accommodate, arises where a Crown action or decision has the potential to adversely affect a proven or credibly asserted Section 35 Aboriginal or treaty right. And I am going to break that down for you. It's one of the standards that we use to measure the conduct of the Crown in achieving the purpose of Section 35 of the Constitution, and it flows from the constitutional principles of honor and of reconciliation. So in order to fully understand that duty, as well as some of the contemporary legal issues that are going on today, it's important that we drill down a little bit into Section 35 of the Constitution Act and understand what is protected and recognized within that section. It's also important that we talk a little bit about honor of the Crown and the concept of reconciliation, and then I will get into some fundamentals of the duty to consult. In order to understand the contemporary challenges, we also need to get into these concepts and into Section 35. Some of the challenges that you may very well be aware of. First, the adequacy of consultation in complex interprovincial projects like the pipelines. And I'm hoping I'll be finishing up by talking a little bit about that, as well as the issue of representative authority and with whom does the government have the duty to negotiate. And some of you may have been following the Coastal Link protests and injunctions in British Columbia, and I'll talk a little bit about that as well. There are also implications of the United Nations Declaration, and there is a new regulatory regime that has been put into place by the federal government, and provincial governments are also reviewing their regulatory regimes. I need 2 weeks, not 45 minutes, to go into all of that. I'm going to be focusing on the basics of consultation and the issues of adequacy of consultation, but I'm happy to answer questions about the others to the extent that I can. My expertise is in Indigenous rights, not so much the regulatory processes, but I am aware of some of the changes in the regulatory process. So with that, let's talk a little bit then about Section 35 of the Constitution Act of 1982. Section 35 of the Constitution Act recognizes existing Aboriginal and treaty rights of the Aboriginal peoples of Canada, and it recognizes and affirms those rights. However, at the time that this section was included in the Constitution, there was no agreement among governments as to what the content of that section was. There were conferences that were scheduled to negotiate the content of that section, called the Section 37 conferences. But again, agreement was not able to be reached at those conferences. And this is Bill Wilson and Pierre Trudeau speaking at some of those conferences. They then went into, of course, the Mulroney government. So the result is Section 35 has been filled through negotiation and through litigation. And interestingly, of course, Bill Wilson's daughter, Jody Wilson-Raybould, became the Minister of Justice, and Pierre Trudeau's son became the Premier, and we're still at it trying to sort out the content of this section. So what is recognized and affirmed in Section 35? I think it's really important to start from an understanding that Canadian law is intersocietal. It draws on a number of different legal systems and legal orders. So, for example, we have civil law in Quebec. We also have Indigenous law and land rights that inform Canadian constitutional law, and I'm going to talk about that a little bit. So, this idea of a common law doctrine of Aboriginal rights is what informs Section 35, and that doctrine that came to Canada through the colonization process, through the imperial imposition of colonial law on Canada, recognizes inherent collective human rights that are grounded in prior possession, as well as political, legal, social, and land-holding systems. The doctrine of continuity says that these rights continue into Canadian law unless they were validly surrendered through a treaty process or terminated by a valid active state or are incompatible with the sovereignty of the Crown. With this doctrine comes the notion of parliamentary sovereignty, and that is that the Canadian government is able to enact clear and plain legislation to alter or terminate Aboriginal rights. Now, this is a very controversial point, okay? There is disagreement on how the Constitution is to be interpreted and how treaties are to be interpreted. Indigenous peoples and many legal scholars will say that treaties form interjurisdictional relationships and intergovernmental relationships. provides into Section 35 of the Constitution Act, Aboriginal title. That means the collective ownership and control over land, and Aboriginal title is demonstrated by substantial and ongoing connection to a specific defined territory. What else is continued into Section 35 and protected in Section 35 of the Constitution Act? Other Aboriginal rights that are grounded in specific practices, customs, and traditions that continue to be integral to Indigenous societies. Governance also flows through here. Again, there's a debate with respect to the extent of that governance, the extent of First Nations jurisdiction. However, the policy of Canada has been to recognize certain forms of delegated and inherent rights to self-government. So what else is recognized and affirmed in Section 35? Treaty rights are also recognized and affirmed in Section 35. I don't have the time to go through the history of treaty and all the different treaties, but I have three important points that I want to make about treaties as they relate to the duty to consult. So the first point I want to make is that not all treaties address land issues. So for example, in Eastern Canada, we have what are called treaties of peace and friendship. Those treaties of peace and friendship in Eastern Canada have to do with military relationships, access to certain rights and resources, protection of certain rights and resources and trade, but they did not address issues of land. What that means in the context of consultation is that there are obligations not only in relation to the treaty rights, but that the duty also extends to credibly asserted Aboriginal rights in these areas that were not addressed through the treaty process. After the Royal Proclamation of 1763 and the capitulation of the French, the principles for negotiated surrender of land were set out as part of the Canadian constitutional process. That is the process of surrender by treaty in open public in exchange for consideration and other promises. However, again, there's significant disagreement in some contexts with respect to the nature of the treaty relationship that is created by these treaties, as well as the extent of rights that are protected by these treaties. So what does that mean for the duty to consult? It means that honor of the Crown requires a propulsive interpretation of these treaties that includes oral promises and implied terms, because there were many terms of treaties that were not written down. It was kind of like a pre-formed contract that was taken around and then discussions happened around it. So there were many terms that were not included in the express terms of the treaty. What does that mean in terms of consultation? It means that when government actions may potentially adversely affect a recognized treaty right or a credibly asserted right, there is a duty to consult. Okay? In 1973, we got the first decision from the Supreme Court of Canada recognizing that Aboriginal title survived the assertion of Crown sovereignty, and that indeed in British Columbia, the legislative regime there did not clearly and plainly terminate Aboriginal title. So in 1973, when this decision came down, there was lots of what we call unceded territory. That is territory where no treaties had been negotiated. So on this map in the yellow is all of the unceded territory. So this is going to become important in the context of the Coastal GasLink litigation in a moment, which I'll talk to in a couple of points in this presentation. But before I talk about that, I want to talk about this word existing. Because Section 35 only protects existing Aboriginal treaty rights of the Indigenous peoples of Canada. This was part of the provincial buy-in, and in fact was proposed by Premier Lougheed of Alberta and some others. What it means is it's only rights that have not been terminated by a valid act of state that are protected in Section 35. So our jurisprudence recognizes the ability of the federal government to terminate an Aboriginal right as long as it is clear and plain in its intent to do so. Okay? So if that has happened, the right is not protected in Section 35. And sometimes our litigation is about, was it terminated or was it not terminated? Is it protected or is it not protected, right? So those rights come through and are protected as well as treaty rights. So by way of example of unceded territory, what is recognized and affirmed in that unceded territory? Well, let's take British Columbia as an example. In British Columbia, there are reserves, but most of these reserves, with the exception of a few in the Douglas treaties, were not created by way of any kind of negotiation with respect to traditional territories of the Indigenous peoples who live in British Columbia. Rather, as part of the terms of union and following that, the Kenna McBride Commission, there were different reserves that were granted in different places where Indian villages were located, but there was no negotiation with respect to traditional territories. As a result, there have been numerous decisions of the Supreme Court of Canada that recognize both the continuity of Aboriginal title in British Columbia as well as Indigenous laws and institutions that continue to be integral to the Indigenous peoples of British Columbia. And I've cited some of the cases there. So one of the complications that this creates is that we have two systems of governance going on in British Columbia. We have the hereditary chiefs governance system, which is a system of extended families who hold territorial rights to specific territories within British Columbia. And they are the Section 35 rights holders. Their rights have been recognized, but they have yet to been negotiated or affirmed through treaty, except in Nisga'a territory. Okay? In addition to that, we have reserve band councils. So we have two systems of governance going on the unceded territories of British Columbia. And this, of course, is going to have implications for questions like who do we negotiate with and where does the duty to consult lie. And I'll come back to those points in a moment. So what else is recognized in Section 35? The treaty reference in Section 35 also refers to modern treaties. Modern treaties are part of the reconciliation process. Following the 1973 Calder decision, modern treaties were entered into throughout most of northern BC, some of northern Quebec, and the Nisga'a Treaty in British Columbia. There are currently, I think, about 120 tables in operation negotiating in British Columbia right now. I don't know the exact number, but there are negotiations ongoing with respect to modern treaties. Importantly, the Supreme Court of Canada has said that modern treaties are a really important step in the process of reconciliation, but they are not the end point. The honor of the Crown continues to apply to these treaties. And as we will see shortly, there are numerous duties that flow from honor of the Crown, including the duty to consult. So what is this honor of the Crown then? What am I talking about when I mention honor of the Crown? Honor of the Crown is actually a historical principle that dates back to early English law when the sovereign was actually a person who wielded arbitrary power. Okay? So honor of the Crown is a standard that developed against which conduct by or on behalf of that sovereign could be measured, and is a limit on the arbitrary exercise of power by the sovereign and its representatives over the subjects and their property. This concept still continues to apply outside of Section 35. For example, if my property was to be expropriated to put in an LRT line, there are certain common law obligations as well as statutory obligations with respect to my right to be heard, the fairness of the procedure that has to be followed, whether or not I'm entitled to compensation. So this concept has context outside of Section 35, but it also has a particular context within Section 35, and it informs the obligations that are in that section and the protections that are offered by that section. It has as its ultimate purpose this idea of reconciliation of the Crown's assertion of sovereignty over the pre-existing sovereignty of Indigenous peoples. The idea of reconciliation of the power of the Crown over the title and the rights that have continued into Canadian constitutional law, and somehow finding a balance in that process. And it generates different duties and standards against which conduct by or on behalf of the Crown is going to be measured in the process of reconciliation. So I mentioned that this idea of honor of the Crown gives rise to numerous different obligations. It gives rise to what we call fiduciary obligations when the Crown, for example, exercises discretion over reserve land under the Indian Act. Okay, that's just one example of a fiduciary obligation. It applies to the interpretation of the treaty and constitutional provisions that affect Indigenous peoples. It imposes on the Crown a duty of diligent and propulsive fulfillment of treaties and other promises aimed at reconciliation, and it gives rise to the duty to consult and sometimes to accommodate. So honor gives rise to a number of different duties depending upon the particular context that we are talking about. So I mentioned that reconciliation is also a fundamental principle in the duty to consult. The reconciliation of Aboriginal and non-Aboriginal Canadians and a mutually respectful long-term relationship is the grand purpose of Section 35. That is what our Supreme Court has said. Reconciliation takes as its starting point the historically based and recognized rights that I just talked about. But it also takes into account a broad range of other factors such as modern conditions of the land, modern needs of Indigenous peoples, as well as the interests of third parties and society at large. And that, I think, is a really important point. Because what that means is that reconciliation does not dictate a particular substantive outcome. It has to take into consideration interests of all the parties, and therefore there is no veto in favor of Indigenous peoples under Canadian constitutional law with respect to the duty to consult. This point was really brought home in the decision that just came down on Tuesday by the Federal Court of Appeal, which I hope to talk a little bit about at the end of my talk. So when then does this duty to consult arise? What triggers the duty to consult? The duty to consult arises in two specific contexts. The first is justification for infringement of an Aboriginal treaty right that's been proved before the court. Now this is a complex law school diagram here. But the point is, once Indigenous peoples prove their Aboriginal right, the Crown has an obligation to justify infringing that right. And part of that process is consultation. Now, it's really important, and I do want to make this point, that Section 35 is not part of the Charter. Section 35 exists outside of the Charter, which means that Section 1, which limits and says we can limit our Charter freedoms based on fundamental principles of a reasonable and democratic society. Am I close, Pat? Okay, there you go. So Section 1 says that. That doesn't apply to Section 35. Okay? So this is kind of like a Section 1 test, right? This test says that if the Crown is going to interfere with Aboriginal rights, it has to meet a test that's kind of like Section 1, and that involves consultation. The second circumstance under which consultation is going to arise, oh, and I should make the point back here, that both of these types of consultation are going to apply in these complex projects, because there's going to be proven rights and there's going to be credibly asserted rights. Okay? So the duty to consult also arises where we have credibly asserted, unproven rights. So credibly asserted treaty rights or credibly asserted Indigenous rights, Aboriginal constitutional rights. It arises when there is knowledge, actual, or deemed. The Crown, for example, is deemed to know that if there is a claim for traditional territory, there's a credible assertion for rights there. Okay? Conduct or decision contemplated by the Crown is the next criteria. They have to have some conduct that they're contemplating that they know might have some kind of potential adverse impact on one of these rights. And it's important to emphasize potential adverse impact and knowledge. It's not the strength of the claim that triggers the duty to consult, nor is it the strength of the potential impact. That goes to how much consultation you must do and the depth of the consultation. The fact that there's a potential impact and you have knowledge and there's an action that can create that impact triggers the duty. So what then does that duty entail? The duty always entails meaningful dialogue with a view to substantially addressing concerns. Okay? However, the depth of consultation that is required. And how we define what is meaningful depends upon whether you've got a weak case or a strong case, and whether you've got a significant impact or a not particularly strong impact. Okay? That's going to affect the depth of consultation that is required. And it is up to the Crown to assess the potential claim and the potential adverse impact and to inform the potentially affected First Nations. So the obligation is on the Crown to make this assessment and to inform the First Nations that are potentially affected. So what is reasonable and meaningful dialogue? This is at the heart of the issue of the Northern Gateway and Trans Mountain litigation, which I will get into a little bit. All consultation has to be reasonable and meaningful. But what is reasonable or meaningful is going to vary depending upon the depth of the consultation required to achieve what is called reconciliation. It is always characterized by good faith, trying to understand each other's concerns and moving to address them. It has been described as possessing a state of open-mindedness when you come to the table to dialogue. It's a two-way dialogue, and it's more than just an exchange of information. You have to try and address each other's concerns. So before I get into those cases, I just want to say a couple of things about the duty to accommodate. There isn't always a duty to accommodate. That is to change or add conditions or to reach particular agreements of accommodation. The duty to accommodate arises when there is a strong prima facie case and the government's decision may adversely affect that right in a significant way. That is when the duty to accommodate arises. So if you've got a weak case, minimal impact, the duty to accommodate may not be there. You still have an obligation to dialogue in a meaningful way, but there may not be any duty on the Crown to make an accommodation. However, accommodation does not mean consent. It means seeking some kind of a compromise in an attempt to harmonize conflicting interests and move further down the road in that path to reconciliation. So for this reason, the Supreme Court of Canada has consistently maintained that the accommodation does not give a veto to project development to Indigenous peoples. There is no duty to agree. Now, as we move towards implementing the United Nations Declaration, I would argue there is still no veto, but there is a duty to try and negotiate an agreement. You can't just impose an accommodation. And hopefully I'll have time to talk about that a little bit. Examples of accommodation here could be requiring industry to amend its plans, to legislate or regulate. So these things can be done absent agreement and may still be found to be reasonable accommodations. But as we're moving towards implementing the United Nations Declaration, there's more of an incentive to negotiate towards consent, but there is no veto. And I don't think we can have a unilateral imposition without discussion and trying to reach consent. So what are the obligations of the Indigenous peoples within the context of the duty to consult? They also have duties to articulate their asserted rights and concerns with sufficient specificity so the Crown can assess the strength of their claim. They have the duty not to frustrate good faith attempts at consultation. They have a duty to respond and participate in the processes that are made available and to engage in good faith, meaningful dialogue. One of the questions that arises is consent ever necessary? So there was a big decision that came down in 2015, the Chilcotin decision, which recognized the Aboriginal title of the Chilcotin people in northern British Columbia. And it said they had Aboriginal title. And the court says when you've got a case like that that says you've got Aboriginal title within this specific region, and it's been affirmed by the court, then you need consent. Okay? However, it's still not really absolute consent. I wish they'd stop using that word. Because, in fact, if consent cannot be reached, then the government can still justify interference by that justification test. Now, that's a much harder tougher test than consultation and accommodation, but government can still justify interference under Canadian law. But it is a significant incentive to negotiate towards consent, because that is a much tougher test to be able to meet. So who carries this duty? Who can implement this duty of the Crown? Again, this is a bit of a complex diagram. The point here is that the Crown has the ability to delegate the process of consultation, the procedure of consultation. They do this through industry, entering into negotiated agreements with First Nations. They can do it through their existing environmental and energy regulatory processes, as we're going to see in Trans Mountain and in the Northern Gateway case. And they can also do it through direct dialogue. Usually when you have a complex consultation like Trans Mountain or like Northern Gateway, it's going to involve all three of these processes, okay? And importantly, only the Crown can assess the adequacy of the consultation. So even if industry has entered into agreements, even if we have a delegated body, it's the Crown ultimately that has to decide whether or not consultation is adequate. So then, of course, the question is, what is adequate, right? What is adequate? So this is where I think Northern Gateway and Trans Mountain have finally started to give us some clarity with respect to these complex pipeline decisions. So adequacy is determined by looking at reasonableness of the process and the accommodation. It's a standard of reasonableness, not perfection. Another important point that comes up again in Coldwater, decided on Tuesday, right? So from the Northern Gateway case, this quote I should say in this case, not in this cast, in this case, the subjects on which consultation was required were numerous, complex, and dynamic, involving many parties. Sometimes in attempting to fulfill the duty, there can be omissions, misunderstandings, accidents, and mistakes. In attempting to fulfill the duty, there will be difficult judgment calls on what is reasonable. Nevertheless, they still found that there was insufficient consultation in that case. So why? So my last 10 minutes, let me talk about these first two things that I've put in bold, and then I'll open things up for questions. So these are really four of our major challenges in the area of consultation right now. The first is, what is meaningful dialogue and adequacy of consultation in the context of large projects with geographically dispersed effects? That's Northern Gateway and Trans Mountain. Secondly, what about issues of representative authority? That's coastal link litigation, and I'm definitely going to spend a few minutes talking about that. Then another important question are, what are the implications of the United Nations Declaration on consultation if we're going to move towards negotiating consent? And last but not least, the changed regulatory regime. How does it improve the consultation process for Indigenous peoples? How does it improve consultation for issues of the environment? And what are some of the concerns of industry in moving forward with certainty and abiding by a new regulatory regime? So Trans Mountain, the Northern Gateway pipeline case was decided in 2016. It was a case that had significant support by Indigenous equity partners, as well as many of the people along the pipeline route. There were 4 phases of consultation in that case that took place over numerous years, including a hearing by the National Energy Board. The issues in the consultation were not with the actions of Enbridge. They were not with the actions of the Energy Board. They were in the final phase of consultation between the government and the Indigenous peoples. So this consultation process anticipated 5 phases, one of which involved a direct Crown consultation on the report issued by the Joint Review Panel before it would be approved by the Governor General and Council. I'm just going to skip to this slide, which is what were the inadequacies in that process. Canada did not consider or respond to concerns that imposed an arbitrary timeline, short timeline. Canada's representatives that came to the table did not have decision-making authority. They were mandated to gather information and send that information back to decision makers. So what was missing, the court says, was a real and sustained effort for a two-way dialogue. In 3 instances where First Nations identified inaccuracies in the report, in the Joint Review Panel report, and identified them to Cabinet, Canada was not willing to discuss or respond. And many impacts of the project, some of which were identified in the report, were not addressed. Rather, a general letter was sent out to First Nations essentially saying, don't worry about it, we'll take care of your concerns. Okay? They didn't respond to the specific concerns. So, the pipeline is not approved. Eventually, of course, the Trudeau government introduces its tanker legislation in British Columbia. So the pipeline, that particular pipeline, Enbridge decides not to move forward. What about Trans Mountain? Well, Trans Mountain was going on at the same time and the Northern Gateway was making its way through the courts. Okay? It was going through a similar consultation process. And it received a number of, however, there was another complicating factor. The National Energy Board was in error when it concluded it did not have jurisdiction to consider species at risk and the impact of oil tanker traffic. So they did not have sufficient information in the eyes of the court to make a decision on the environmental issues. As you can see here, there was extensive Indigenous consultation, including in Phase 3, where federal representatives met with 117 First Nation communities. However, again, a significant problem because Canada was required to engage in two-way dialogue, and again, representatives were not able to discuss accommodation or take any recommendations back. Canada also was not willing to make changes to the conditions that were issued by the report of the National Energy Board, and was mistaken because in the Gitsala case, in the Northern Pipeline case, the Supreme Court of Canada had said that Canada has, the Governor General and Council Cabinet, the federal cabinet, has the ability to impose additional conditions. Okay? But Canada was under the mistaken belief that it could not. And also very problematic was late disclosure of the assessment of impact. It came out really late after almost all of the consultations had been completed. So, let me finish then with the Coastal Link litigation and with the decision that just came down on Tuesday. What happened after the Supreme Court of Canada ruled on consultation is the National Energy Board had another hearing, took into consideration species at risk, issued a bunch more conditions, 60 more conditions to attempt to address that. Justice Yakabuchi, formerly of the Supreme Court of Canada, was asked to lead in the Indigenous consultation process, which he did. Nonetheless, there were still several challenges. One was from British Columbia when Premier Horgan came into his position, and they challenged the constitutional validity of the decision, saying that a province has the right to control hazardous materials within its province. However, the Supreme Court of Canada came down unanimously saying that interprovincial pipelines are federal provincial jurisdiction and it would create chaos if every province could rule what runs through those particular pipelines, right? So we also had then challenges by many First Nations and environmental groups. Only one of them was accepted, and that's the one that came down on Tuesday. There was a challenge by Coldwater Indian Band, the Squamish Nation. So these First Nations were on the pipeline corridor and impacted by it. Cold Lake was concerned about the impacts on its drinking water. The others more so about impact on the oceans and the tanker traffic. They argued that Canada came to the table, one of the arguments was that Canada came to the table with a mind because they now owned Trans Mountain, and so they would not be willing to make accommodations. And here is what the court said. The court said, contrary to what the applicants assert, this was anything but a rubber stamping exercise. The end result was not a ratification of the earlier approval, but an approval with amended conditions. It is clear applicants are of the view their concerns have not been fully met. But to insist on that happening with respect to every First Nation along the pipeline is to impose a standard of perfection rather than a standard of reasonableness. And that is not what is required by law. They also said that many of the problems that were addressed in the Trans Mountain case with respect to meaningful dialogue had been addressed in the second go-round of consultation. Also important what they say about reconciliation. This case talks a lot about reconciliation and about honor. Reconciliation can be advanced through consultation when the respective parties commit to the process, avoid counterproductive tactics, get to the substance, and exercise good faith. Indigenous peoples can assert their uncompromising opposition to a project, but they cannot tactically use consultation to try to veto it. Tactical behavior aimed at ensuring that discussions fail within the time available for consultation is not consistent with reconciliation, and if tolerated, would amount to a veto. Okay. So those are some of the key points that came down. I'm going to skip the other slide because I do want to say a few words about Coastal Link and leave some time for questions. So the Cold Lake and other First Nations now have 60 days within which to appeal to the Supreme Court of Canada, but they must show that they have lawful ground for appeal. I'm not confident that that application would be successful. So the other decision that has been a very important one, and one with which I have some significant concerns, is an injunction decision that came down in British Columbia. Remember I told you that there are two forms of governance operating in British Columbia right now, and that the Supreme Court of Canada has indeed recognized the traditional governing systems of the Wet'suwet'en people as well as their rights to a land claim. So those are in negotiation, they have not yet been resolved. So there are currently blockades going up with Coastal Link, and some of the Wet'suwet'en hereditary chiefs brought an application to prevent the pipeline from going forward until they were consulted with respect to their land. And according to their law, it's the hereditary chiefs who have the right to enter into negotiations, and that their consent is needed in these unceded territories. So there have been agreements made with all of the Indian Reserve Band Councils, who have jurisdiction over the reserves, but not with all of the hereditary chiefs who have jurisdiction over the unceded traditional territories. All right? But this is what the judge said, which I think is highly controversial. It says, Indigenous customary laws do not become an effectual part of Canadian common law until there is some means or process by which Indigenous customary law is recognized as being part of Canadian domestic law. There has been no process by which Wet'suwet'en customary law have been recognized in this manner. The Aboriginal title claims of the Wet'suwet'en people have yet to be resolved either by negotiation or litigation. While their laws clearly exist on their own independent footing, they cannot be recognized. In my view, this is completely contrary to what has previously been said by the Supreme Court of Canada. In the Delgamuukw case, the Supreme Court of Canada clearly said that rules governing Aboriginal title draw on Canadian law and Indigenous legal institutions, that we are to look to Indigenous land tenure systems and laws to ascertain the content of title. It confirmed that the Wet'suwet'en never surrendered their title, and in my view, therefore, the duty to consult extends beyond the reserve bands to the traditional governments. Now again, the standard is not perfection. The standard is reasonableness. But the Premier has to date refused to meet with the hereditary chiefs directly on these issues. As a result, there's been an open letter also sent to Prime Minister Trudeau, signed by many leading Indigenous scholars, saying that the duty to consult want to wind back to this case because I think it really brings to the forefront some of the challenges that we have in consultation in unceded territory. Yeah.
Just if we go back to like 2016, 2018 ruling for the consultation, I find it really interesting that like the rulings for both of them, because we're currently reading both of them right now.
Yeah.
That the final decision is almost identical word for word in their decision-making processes. But it's really more interesting in 2018 when they really slapped NDP and said that the quasi-judicial process is really justifiably narrowed in their scope, even more so than previous rulings of what was dealt with and such. So I'm kind of wondering, like, because they didn't specify that, they weren't considering specific and identifiable concerns. And that was another court case, and it's a non-indigenous court case with non-indigenous landowners in BC suing Trans Mountain for that exact same reason, that there are specific and identifiable concerns that have not been addressed in the consultation process. And this is where, like, I couple of eyes on indigenous relations engagement issues. I always tell the opponent, it's not just indigenous communities you have to be consulting, but it's these non-indigenous. So would this be something that, they could kind of go back and say, hey, this 2016 ruling, this 2018 ruling, they highlighted specific identifiable concerns must be addressed. Why aren't we addressing ours?
So there is a difference between the obligations to consult Indigenous peoples who have treaty rights or Aboriginal rights or credibly asserted claims and the general public. The obligations to Indigenous people flow from the constitutional protection of those rights, and therefore I would argue are constitutional rights that are somewhat more onerous than what might be applied to the general public. Having said that, there are rights for public participation where they are directly affected. They do have common law rights to compensation, right? And they do have the right to have their concerns be heard, okay? But there may not be the same, I'm not an administrative law person, but it may not be that the same level of specificity or detail is required outside of an Indigenous context. I'm not sure.
They do have treaty rights under treaty.
A different kind of treaty right. So when we enter into treaty, so I'm a member of Treaty 6 because I can't be on Treaty 6 territory as a non-Indigenous person without that treaty having been negotiated. So there's two parties to a treaty, exactly. But the rights of Indigenous peoples to a treaty are different from the rights of non-Indigenous peoples to a treaty when it comes to consultation under the Constitution. But I agree with you, there are still consultation obligations. Yeah.
Dr. Bill, do you think consent and veto have now become conflated?
I'm sorry?
Do you think consent and veto have now become conflated
Yeah.
by governments, project proponents, and now the courts?
One of the questions is, the question that's raised is have consent and veto now become conflated? And I think that's a really good question. I think there's a lot of confusion around what consent means. Even if we look at the United Nations Declaration on the Rights of Indigenous Peoples, it says that we are to obtain free, prior, and informed consent in a variety of different contexts, including these kinds of impacts on traditional territories, Aboriginal and treaty rights. The free, prior, and informed consent doctrine, however, is also not absolute, right? One can justify overriding that consent, but on much harder criteria than exists under the law of consultation. It must be absolutely necessary to uphold other human rights, for example. So the language of consent is used in a lot of different ways within these legal contexts that are different from our common understanding of what consent means. If we take consent to mean I have the arbitrary right to just say no, that's not consent in law. And it's not consent under the United Nations Declaration either. In this context, there's another context, right, like criminal law, right? So in this context, so that word consent, I think you made a really good point, is we're constantly conflating consent and veto. And so for some to say, oh, you don't have veto power, therefore I don't have to negotiate towards consent, no, that's wrong, right? Especially if title is proven, and especially if we're trying to implement the United Nations Declaration. We should be moving towards negotiating consent and not imposing accommodations, right? But there still is no absolute arbitrary a very good point.
So, and I think, kind of veto in the common parlance now has dissuaded from legitimate Indigenous rights concerns around these major resource projects,
Yeah.
right?
Yeah. I think veto is sometimes used to suppress people bringing forward their concerns, and that's a real problem. I agree with you.
Great question. So I'm teaching the Department of Secondary at NUA. We
Yeah.
talk a lot about multiple perspectives.
Yep.
And so my question is, as a layperson to law, who's sitting at the table when it comes to judges and lawyers? And are there Indigenous lawyers and judges who are also, at the final decision-making stages or to interpret some of these? Because to me, this comes down to a question of interpretation and language.
I think, again, that's an excellent question, and it's one that Bill C-69 and the new regulatory framework is addressing in a limited or perhaps not satisfactory way. So under the new regulations, there has to be Indigenous representation on the board, on the decision-making board. I can't remember the new names. It's the Energy Regulator and the Impact Assessment Board, I think they're called now. When they are rendering a decision, the new regulations provide that there has to be Indigenous participation there. It also provides that there has to be Indigenous engagement at the point of assessing the impact and the strength of the impact of the claim. It also refers to, and always has referred to having to take into consideration Indigenous knowledge, but now it removes the word traditional, so it's not defined in a particular antiquated way. And it also provides for protections, and it also says that in rendering a decision, whether it's the board or whether it's the governor and council, in making their decision, if representations have been made with respect to Indigenous knowledge, they have to say what was presented and how they took it into consideration. But there are also protections around disclosure so that that sensitive knowledge is not revealed to everybody. So one of the strengths, I think, of the new reforms is it starts building in better participation in the actual decision-making and not just in the presentation. Having said that, in my view, we do not have enough Indigenous lawyers, we do not have enough Indigenous judges, we do not have enough Indigenous people sitting on these regulatory bodies that are making fundamental decisions about our future. This system is broken.
Amazing presentation, thank you. One of the parts of the recent decision of the federal court that troubles me most is the statement that because none of the traditional law has been accepted into the electorate. So how do you tie that determination with your argument for the new federal assessment process? I think that there is not the clarity there and the whole thing.
So the question is, how do you reconcile decisions, if I've got this right, by lower court judges who say that Indigenous law is not recognized yet against this idea that I mentioned, that I think it's getting better because we have representation in some of these decision-making bodies. So let's come back to the coastal link decision again. I covered it very briefly. One of the things that is important in being able to get an injunction to stop something before you actually have a trial on the issues, a substantive trial on the merit of the case, is you have to show that you're suffering irreparable harm, and that irreparable harm outweighs the harm to the people who are putting the pipelines through and all the people who are affected by that. Okay? If you read through the reasoning in the Coastal Link case, it is a reasonable argument on the balance of irreparable harm. Where it's really problematic is what it says about Indigenous law. I think that really speaks to the need for judicial education. There is more of that going on, but speaking to what the implications of what these decisions are with respect to recognition of Indigenous law is very important. And we need more judicial education. Many of the people who are sitting on the bench or on these decision-making bodies were not even in law school when we had courses in this area. When I started teaching in 1989 at the University of Alberta, there were like 3 courses in the country on Aboriginal rights, right? So many of the people who are sitting on the bench may not have the familiarity that they should have. describe in any detail at this point. Yeah,
Wasn't the decision on coastal last week,
yeah.
didn't the judge actually say that the blockade was the issue? And that even under First Nations law, that the blockade was offside?
So the other thing, and thank you for that point, the other thing that came up in the Coastal Link decision is the judge found it difficult based on the evidence before him to rule directly on what the law of the Wet'suwet'en people was, and felt that there was disagreement on that, and that those kinds of evidentiary issues are best dealt with at trial. There was also concern raised about peace and the blockades. So those were other factors that were taken into consideration in the decision making.
So, thank you for explaining that. And, we seem to have two different interpretations of the, who's on the internet.
Yeah.
So what happens next? How does this get resolved? Is there going to be a appeal? Is there a trial going to happen? Is there going to be some? How do you get past it?
So what we have is a system of legal pluralism where Indigenous laws survive. We still have a system that recognizes the ability of Canadian law to trump that law, but it can only do so if it meets certain criteria. One of those criteria is to engage in consultation. Okay? But there is a disagreement as to the extent of what laws survive, right? The extent of what government survives, but these are still credible claims. So I'm not saying that if it comes up to the Supreme Court of Canada, they're going to say Wet'suwet'en law trumps Canadian law. But there are credible claims that these laws must be taken into consideration because the territory is still unceded, and therefore there's an obligation to talk about it and try and come to some reconciliation. The courts have consistently pointed us to negotiation because of this. And this idea of reasonableness, that we must sincerely come to the table with good faith to hear each other's concerns and to try and accommodate those concerns. That's what they're saying. If there's a credible claim, like this credible claim that I put forward, I'm not saying it's necessarily going to win if it goes to the Supreme Court. I have my views about whether it should or not, but it's a credible claim. So when we have a credible claim, there's a duty to talk and try and resolve our differences. Otherwise, we're in court.
Well, unfortunately, it's 1 o'clock or shortly thereafter, and I know that some of you have to get back to work. So I guess I just want to thank you, Professor Bell, for a very full, informative talk. I think nothing else would come away knowing that duty to consult is not a simple thing. It's contextual in so many different ways. And in fact, just judging by the nature of our audience and the number of questions, it may be that we try to convince Dr. Bell to come to the university, to give this talk again at the university, because I think there's so much more to be said. But I'd just like to thank you on behalf of everyone here. Would you join me in And some of you have asked whether or not the materials will be available. So you know that we are web or taping the presentation. It'll be available on our website sometime in the next couple of weeks. It has to be they have to do something to it. And it takes a little while. So we'll let you know as soon as it's out. And so if you're not on our mailing list, please do sign up so that you can get that information. And we'll ask Professor Bell if she will let us use her PowerPoint, which we will also post so that you've got that available to you as well. So please do sign up. And lastly, please do sign up on your feedback forms. We'd love to hear your feedback. So thank you so much for your participation. Next month, we're going to host Professor Cameron Jeffries on climate change and Section 7 of the Charter. So hope to see you here.